Kano politics have always been quite interesting and intense. Sometimes the situation is also unpredictable and the actors are vigorous in the pursuit of their various and conflicting interests. The Court of Appeal sitting in Abuja has fixed Monday for hearing of the appeal filed by Governor Abba Yusuf of the New Nigeria People's Party challenging the nullification of his election by the Kano State Election Petition Tribunal. Already there is apprehension in the state as the appeal court are set to hear the matter. A prominent lawyer and senior advocate of Nigeria, Femi Falana, has faulted the judgment of the Kano State Election Petition Tribunal. He says the judges cannot punish voters because of an error committed by INEC. Another lawyer and activist, Kabir Akingbolu, says the Kano Tribunal judgment should not stand. He says the tribunal lacked jurisdiction to declare the APC candidate in the election as the winner after nullifying certain votes given the state of Nigeria's electoral jurisprudence. He insists that it is clear the judgment of the tribunal is a total miscarriage of justice.
Well, in a lot of ways, the judgment more or less stepped the law on the face squarely. In a lot of ways, because since the decision have been as an onlooker and a practitioner in that area of the law, I have been a bit worried because it's more or less shifting, the goalpost of our judicial precedent to another unknown realm. So, and this is worrisome. That is just the truth of the matter, because the tribunal made a lot of somersaulting findings. Like in one aspect, the tribunal said it cannot go on a voyage of discovery to know the ballot paper, where the ballot paper was not, why they were not marked with official mark or something. At the end of the day, in another area of during their finding in the course of judgment, the tribunal said that it has the right to go on a voyage of discovery to look at the document tendered where no witness, said anything about them. And the tribunal also went to say that dumping of document, does not arise here, which means it's a tacit admission by the tribunal that those documents were dumped because there were no witnesses to really relate them to the case presented before the tribunal. So the tribunal was now saying that because of Section 137 of the Electoral Act, that it allowed them to look at the ballot papers, to look at the results and make findings on them. So this is quite funny, because there are two findings that cannot stand. That you can't go on a voyage of discovery, and at the same time you say you can go. The law that guides admission or admissibility of document is the Evidence Act and not the Electoral Act. Section 137 of the Electoral will not change the law, especially now. I think it is easier now, because at the time the tribunal gave its judgment, the Supreme Court has not spoken about Section 137. Section 137 was interpreted by the Presidential Election Petition Tribunal, which is the Court of Appeal, in the case of Atiku and INEC, and in the case of Peter Obi and INEC. And the Supreme Court has found those decisions to be good. And what the court was saying, or what the court said, was that irrespective or notwithstanding the provision of Section 137 that says the tribunal can look at documents tendered before them, the court said, explicitly that parties must still prove their case to lead evidence on the documents tendered. So where this is not done, as in the case in Kano, the tribunal was not, on a proper pedestal to nullify the election of the NPP candidate. And again, if you look at it very well, there were few provisions that are very, very, salient to what we're to the issue here. One, if you look at Section 60, Section 60 has to do with the counting of results and declaration of same at the polling units by the presiding officers. You understand? Section 63 has to do with non-counting of ballot paper without official mark that shall be rejected. However, under Section 63, sub 2, it said the presiding officer, once there is no official mark, the result of that unit that will not be counted. But it went further that the returning officer has the right to count such results, even though it doesn't have official mark, if he's satisfied that those those ballot papers form part of the paper that were submitted to or that were furnished to the polling units. So the record is with INEC. It's for INEC to now come. INEC bears this body to say, that these results were not the ballot papers. The ballot papers were not the ballot papers supplied to those polling units in question. If that is not the case, the body of proof is established because by Section 64, Section 64 is read together shows that any result declared by INEC is genuine. So this presumption of regularity under the Evidence Act also, endures in favor of the result declared by INEC. And when you look at Section 64, if you look at Section 64 of the Electoral Act, critically, it highlighted the conditions where you can, certain results may be rejected. That a presiding officer can reject any ballot paper, where there are reason or grounds for that, but that he shall mark such ballot rejected, he shall mark them as rejected ballot. However, under subsection 2 of section 64, it said where the presiding officer take the decision or has taken the decision to reject the ballot paper, any of the candidates or political parties have the right to object to the decision of the presiding officers. You understand? And in such situation, the presiding officer will have to say, this ballot is marked rejected, but objected to. And such rejected ballot, shall not be counted, except where the returning officer, override, the decision of the presiding officer. And in this circumstance, it does not apply at all. The decisions by the presiding officers, were set, to be in order by the returning officer because they didn't express any contrary opinion. If that has not been done, it is taken that the decision of the presiding officers are final. And the tribunal made a mistake in mixing ballot paper, the provision that guides ballot paper, with provision that guides results. Under section 60, it says results shall be signed, dated, and stamped. But in the other provisions, section 64, section 63, it's only saying that ballot papers that have no official mark. An official mark was only referred to in the manual, and that is watermark. That's, watermark is different from signing, it's different from dating, it's different from stamping. And when you look at section 135 of the Electoral Act 2, it more or less says that an election shall not be invalidated due to mistake or some minor irregularities, if there is any in this circumstance. So it means that the law itself recognizes the fact. Yeah, there are a lot of grants, I think there are lots of grants because many other things are arisen, in the notice of appeal filed, but then there are a lot on the issue of lack of proof. There was no evidence, to sustain the petition. And the tribunal, even looking at the judgment of the tribunal, it looks so, because the tribunal itself said the hallowed principle of dumping does not arise, because they rely on section 137. That section 137 allowed the tribunal to look at the document before the tribunal, even if there is no witness to relate those documents to the case presented by the court. But the Supreme Court just recently, in the case of Obi and Atiku, against INEC, they upheld that decision. They said no, irrespective or notwithstanding of that section 137 of the Electoral Act that the tribunal relied upon, that a party still bear the burden of proving and establishing his case by witnesses who will have to link those documents you are relying upon to your case. Not that the tribunal will go on a voyage of discovery as done in this NNPP case, because the tribunal they stated it in the judgment that they have the right to go and look at all those documents and arrive at their decision. It's a tacit admission that there was no witnesses to establish the allegations contained in the petition, and this is very fatal. More so that the Supreme Court has nullified that grant, that section. Not that they nullified the law, but the Supreme Court has said that notwithstanding 7137, any party must still prove their case beyond, in line with the law. So the issue of dumping of document kneels in favor of the NNPP because the APC or their candidate did not prove by evidence all those documents relate to that, and they have not been able to detract from the presumption of regularity attached to the INEC result, the result declared by INEC. So I think in these circumstances, the Court of Appeal will have a better way of looking at it critically and coming to a right decision.
Today,
President Bola Tinubu attended a cabinet retreat where he urged the ministers to perform or be sacked.
are we proud that we are Nigerians? Are we sure that we've done this? Is the responsibility of the permanent secretary clear in partnership with the commissioner? Is it clear? Are we one family? Are we? Thank you very much. Since we are one family and one nation, and we are in this vehicle together, to change the narrative and bring about economic prosperity of our country. Are we ready? The Renew Hope agenda is more than economic growth. Like I said at the opening, we can spend the money, but we cannot spend the people. We have a responsibility to our country to make sure we change completely the narrative about Nigeria. If we have problems, let's talk to one another. Let's have conversations, gentle conversations about our country. It's not about just leave me alone, I'm going home. You may not have a home. There's nothing you can do successfully without good health care, reduction in poverty. Like I said before, poverty is not a shameful thing, but it's not acceptable. Are we going to dig our people out of it? If you look at your background, no matter how wealthy you are today, there's a trace of poverty in it. So it's left for you and I to navigate this ship out of poverty. We have a lot of work ahead of us. I am confident. Now, with the attendance, concentration, you've seen the kind, the quality, and the character of ministers. You've seen it. You've seen the demonstration of knowledge from head of service to accountant general and other civil servants. Yes, we the politicians, we are the soldier go, soldier come. You are the permanent secretaries. But we have to live together. You have no choice. I hope that is clear. I've gathered here to shape the future. No threat about it. The responsibility we bear are not just titles. They are hope and aspiration of millions of Nigerians. You might be ready to forget about the rest of the world, but as a Nigerian, let's go out there. Let's bond together. And make sure our country is fully recovered from elephantiasis. Let me remind you that you are not here to make excuses. Neither am I. I'm your friend, your brother, a father and a grandfather. We must put aside personal ambitions and focus on the progress of our nation. It is through this that we can be truly proud. I am proud standing before you. I'm very, very proud of every one of you. And I am proud of myself too. I went for election, I won with your support. They took me to court, I won. Thank you very much. So we've been here, we've tinkered and tweaked focus areas. Area 1, reform the economy to deliver sustained inclusive growth. 2, strengthen national security for peace and prosperity. Boost agriculture to achieve food security. Unlock energy and natural resources for sustainable development. Enhance infrastructure and transportation as enablers of growth. Focus on education, health, and social investment as essential pillars of development. Accelerate diversification through industrialization, digitization, and creative industry, manufacturing, and innovative technology. I could hear two of the minister, Naji, and I say the satellite is gone. But we say satellite is there. I like that. At least we are thinking. We are deep in what we are trying to achieve. That's a demonstration of knowledge. And I am sitting there as the chairman of Boundary Dispute Commission. It's just too interesting. And I know all of you are, you achieved the goal to end this retreat today because you want to be away for the weekend. No, not because you've exhausted the topic, but the only way to make it happen is to say, hey, we might extend this thing to Saturday or Sunday. So once they're here, they will do the job. I am glad you are doing it, and you've done it. So, today, I thank all of you. I want to obtain a promise from you. That promise is that we promise Nigerians that we are going to work for them. Is that true? Yes. That we are going to work together as a team? Yes. That's correct? Yes. And we are going to achieve for this country. Yes. Let us stand up and say, we are Nigerians. You are a Nigerian. We are Nigerian. God bless you.
He also put Hadiza Bala Usman in charge of the Results and Delivery Unit to monitor performance of ministers.
What is it we do and why are delivery units important to us as a government? Oops. Delivery units really help us to enhance our accountability within the system of government. It provides the details with which we can improve efficiency. It's also based on data-driven decision-making. We need to be mindful of the fact that a lot of times decisions are not taken based on data, and also accountability is not determined by data that has been aggregated over a period. We have seen that a lot of times data are provided that do not speak to the actual implementation. This is why the delivery unit has sought to partner extensively with the Ministry of Budget and National Planning and the Bureau of Statistics, which will provide verified data on the information that has been provided by ministries as results around the delivery of their outcomes. There's also the need and the alignment with presidential priorities. Mr. President has detailed his priorities and all the deliverables and key performance indicators that the ministries have aligned to are taken from the presidential priorities that have been so detailed and discussed extensively with the ministries during the bilateral sessions that was held over a period of 3 weeks between the CDCU, our team, and the respective ministries. There's also the clear trust around a faster implementation. We're all familiar with the bottlenecks that exist within implementation of projects and priority. So the delivery unit will seek to improve and expedite the implementation of government policies and programs by setting clear timelines and monitoring the progress. This is to ensure that the benefits of these initiatives reach the public quickly within a specified period, recognizing that we campaign extensively to deliver these initiatives, and we seek to ensure that they're done within the shortest period. There's also the issue of cross-ministerial collaboration. We've noted evidently that there are areas of overlaps within the course of implementation, and result delivery units seek to enhance that collaboration and also to identify critical areas of enhanced synergy that is required. A quick instance of this is in 2017, we're seeking to improve on dairy farming, and investors were invited and they were keen to invest and they had committed funds. On the other side, an announcement was made that the import duty tariff of dairy products was reduced, and this was completely conflicting policy positions that were announced literally at the same time, and that causes a challenge within implementation. And these are cross-ministerial collaborations, because on the one hand, Agric was striving to improve dairy investment in the country, while the other side, the Ministry of Finance was working on tariffs. So that absence of collaboration resulted in a conflict whereby you have different ministries working not necessarily at the same purpose. There's also the clear need for increased transparency. Where you have a delivery unit, it casts a spotlight on issues around governance. There's clarity on the need for everyone to provide that transparent and accessible implementation mechanism, which will foster public trust in government. It will show that the government is committed in delivering its promises, but is also doing that through an open system where everybody is clear on what it is that it's doing.